regulators and as a public entity or public body. And I will start firstly with the part that's the most mundane one, because just like every other entity, shifting the work from going to your offices every day and working to there to working from home has caused some issues. So in our case, the facilities to there, but of course, as many, we were realizing that maybe the capacity needed to adjust it, etc. Can I ask to go to the previous slide? I think I maybe clicked one too often. Okay, thank you. For us as a board, which means that we have a lot of meetings, we had actually in the last year around 270 of them. This was a massive change to video conferences instead of having in-person meetings. And then the COVID as a topic that has many ties with data protection concerns and privacy issues, it also caused an additional increase of our workload, which meant that we had to reprioritize our work, and therefore some issues that maybe we would have wanted to work on had to be delayed until the ad hoc guidance that was needed at this specific moment could be provided. And lastly, in some member states during the pandemic, the deadlines or certain national deadlines were suspended, which also had an impact on the cooperation of the different members of the EDPB with each other. So you can imagine if you have your members are represented via more than 40 entities in the different member states, getting everybody to work together and have a functioning system can be a challenge. So what were the topics that we encountered? I think it's the topics that many of you are aware of. The change to remote working, I already discussed how it was from our side, but of course it affected unless you were already working mainly from home, of course. And a big impact is also the remote teaching and the change of the daily life for schools. We had to deal with the temperature checks that was started as one of the measures to identify or possibly identify people that could be positive. In total, we issued 7 guidance documents related to COVID, and we issued some additional letters on questions that we received. We had a statement that was already issued on the 19th of March, in which we tried to generally address the issue of COVID or a pandemic in general. Then we issued the guidelines on health data for the purpose of scientific research, which happened in April, so not long afterwards. We had multiple documents related to contact tracing. So the first was we were reacting to a letter by the European Commission, which was providing a toolbox. Then one that was more specific on location data and the use of contact tracing tools. And lastly, we had a statement on the interoperability of contact tracing applications. From the very beginning, the EDPB has said that a pandemic doesn't necessarily respect borders. So we were favoring to have a common European approach. And in this regard, harmonization in the measures that were taken by the member states. Then additionally, we had a statement on the restriction of data subject rights, because in some member states there was the idea to reduce the data subject rights in the context of the pandemic, and on the reopening of the borders. And the topics that we have now recently encountered are the use of drones and CCTV to enforce the social distancing and the wearing of masks. You can see that, for instance, the French Data Protection Authority has recently issued a decision on this. And then the discussion about immunity passports, so vaccination passports already exist, and we know in other countries this is more of a thing, but this will be, to my knowledge, the first time we have a big discussion on this topic in Europe. What were the obstacles that we have encountered is that during the law proposals or generally when measures were implemented, there was often, okay, it should be obvious that this is a problem, so there shouldn't be any issue for us to argue, but that led to that the controllers or the lawmakers did sometimes not sufficiently address the necessity or proportionality of their measures. And then we had also situations in which we had given guidance, and unfortunately, this guidance was not sufficiently followed, which then led to the regulators having to step in again. Then a general issue that's not necessarily limited to COVID, but which became particularly obvious in this case, was that there is a lack of understanding still that we face about what is personal data. So if you remember the contact tracing discussion, there was a lot of confusion whether these diagnosis keys would constitute personal data or not. Then we had discussions about which exemption in Article 9.2 could be used for the processing of health data. So to the understanding of the EDPB, the diagnosis keys should be considered health data, and thereby they fall under the special categories of personal data. And the member states had, for instance, where the contact tracing apps, different approaches to which exemption would be the most appropriate to process these special categories of personal data. And then further, we had an issue about anonymization, anonymous data versus pseudonymous data. So the data that's used by diagnostic teams for us is personal data that indirectly allows to identify people. But particularly in the news or in the public, there was often the talk that the solutions that were presented would be anonymous data, which to our understanding is not correct. It would be nice. It would mean that it's better protection for the data subjects, but unfortunately, as they are identifiers, they still are to be considered personal data. Let me try again. So what was the last thing I wanted to talk about is that we had, in some cases, a lack of consultation. So we were trying to be very proactive, and as I said, we adopted the first statement in March. But we had also a situation in which the data protection authorities or members were unfortunately not consulted or not consulted early enough. So that led to them having to be proactive directly to the controllers and trying to see that everything is done in line with the data protection rules. And these happened for various topics, for the contact tracing apps, for the enforcement of quarantine. And for the most recent example was the privatization of how vaccination candidates should be handled, which is also a topic that is now newer. And the recent example that was in the news was about one of the German Länder ministries that was not collect the age or cannot make a list and prioritize people by age because they have, for data protection reasons, they cannot have access to the data. And the competent data protection authority was quite quick in reacting that it would have been nice if you would have asked us, we could have shown you how you could have done it, which would have helped everybody. So the call to the different lawmakers, etc. The data protection authorities are happy to be consulted on these topics. I see I was talking a bit faster than I was planning, but I think I'm still in time. So generally, there are some COVID-specific new issues that, of course, we have discussed, but it shows that there's still awareness that needs to be raised for data protection, and we will try our best to do so. So thank you for giving me the floor, Prokopios.
Thank you very much, Peter, for providing this overview of the activities of the board over the past year with regards to attempting to respond to the challenges imposed by the pandemic and the very quickly shifted requirements and priorities that we had to deal across Europe, and of course highlighting the work done also by you and the national regulators. I would like now to pass the floor to Rosa to the private sector. What has changed over this past year? Rosa, the floor is yours.
Thank you very much, and hello everybody, co-panelists, Prokopios, and many people who are in many different locations around Europe and beyond. So as Prokopios said, well, also thank you, ENISA, and thank you for this putting together this panel with a very, very timely, very good topic that fits very well. So my perspective, as Prokopios said, is going to be the perspective of compliance. So as a lawyer, I have been helping companies who have been putting in place new data collections. Peter already alluded to these new collections from temperature to COVID apps. So all of this has happened. What I am seeing that companies are doing to comply with the GDPR and so do that in a lawful way. So rather than I won't jump straight to this topic, just as before I would like to see. I wanted to just mention two points. First, just summarize the changes, summarize a little bit the risk, and then straight go into what I have seen that has been done. What are companies doing? So changes in working habits. What are the kind of 3-4 points that I think have been very relevant? So obviously the moving from the offices to homes. So working from homes is number one. Number two, the related use of video conferencing rather than one-to-one meetings. Number three, the use of COVID tracing apps, and by COVID tracing apps, I don't mean only the state ones, and we will hear, but the ones that sometimes some companies are implementing, and that are simply from only for the company itself. And then the myriad of collection of data from temperature to places you have visited, your symptoms, and blah blah blah. So these four items that I think have kind of exemplify the big changes that we have seen in 2020. Now, these items have brought about some sort of risks. And then we will see what companies have done to cope with the risk. But the risk that I basically identify would be working from home with the more insecure connections, insecure, probably more prone to phishing attacks. Um, Probably we see, I guess that we have seen a lot of sometimes insecure devices. The risk related to the use of video conferences, sometimes we have seen people that are being filmed, they didn't know, the use of film or for purposes that they were not intending, retention for longer than is necessary, and pretty much the same ideas vis-a-vis the information that is collected in the context of COVID. So, for example, the information collected related to infections, related to with whom you have been close, there is the risk of this information perhaps being misused, perhaps being put somewhere else where it shouldn't have been, access given to people who shouldn't have. So this is what, let's say, we have been seeing in 2020. Now I go to what, as a lawyer, when a company has come to me, to my team, and told us, well, we are going to put in place these measures, what I have seen that is we are seeing as main compliance measures. To give you a sort of examples. Okay. Next slide.
I already changed to the next slide.
Still another one? Next one. Next. Yeah, I can do it without. It will be nicer with the slides, but yes, I can get started without. Okay.
Should I stop sharing?
All right. So I get started with the measures that we have been putting in place. First one, what we have seen is many companies have policies about how to use your own device, how much internet you can use from home, how you can use it, what you can do. Well, these policies sometimes were in use, but what we have seen is a focus on these policies, redoing the policies, adapting the policies. So just to give you an example, some companies might have thought, well, we need to establish very well when you can use the company device for private use. Can you use email, your private account, your Gmail, your Yahoo account? How much can you download from this using the device? So all in all, we have seen what I would say revisiting the company policies a lot. Number two, quite important, we have seen a revisiting and boosting what is incident response plan. So companies are more and more aware that data data breaches might happen, and they are building drafting data breach response plan, which will put in place a plan of what are you going to do as a company if you become aware of a breach. So pretty much what this means is making sure that when the data breach occurs, you have already, for example, your forensic company to come and check. You have your PR company that is going to give I'm talking, of course, of big companies. That is, so the PR company that is going to, for example, communicate with the public. You need your insurance company. How much can you be covered? Of course, you need your lawyers. So the incident, I have seen an uptick in looking into these incident response plans and making sure that they are properly drafted. And not only that you have them there in the drawer, but what we have seen is a lot of rehearsing. So what is typically called tabletop exercises, where you have people in the company, each one adopting a different role and imagining that data breach happened on a Friday afternoon. What would you do if this happened? So rehearsing over and over, so that when this happens, you know how to react. So that is a preparation that I have found that it seems very useful, and you see companies doing it. Now, point 3, we have seen a lot of breaches. I think that this is even if there is preparation, this year, perhaps because people are working from home, perhaps because to some extent there is more phishing attacks, and maybe the distraction, but it is not uncommon that some employees open phishing emails, and this leads to phishing attacks and sometimes even ransomware. So we have seen quite an uptick, I would say, of these attacks leading to ransomware. And sometimes, maybe surprisingly, in companies that you would not expect, basically companies that might be engaged in B2B companies, engaged in manufacturing, machinery, spare parts, where the main asset is not data. The main asset, they produce something that is not about data. So these companies might have not thought that they will be the target, but you see that they are. So once a target, we have helped many companies. So once it happens, so there is, as you know, according to the GDPR, you might need to notify the data protection authorities. If the breach happens in many member states, you have to go to each one of the regulators, notify of the breach, and essentially, in some cases, notify individuals. So this has been, quite predominant work done. So I guess that training, Next one is, yeah, we have seen companies that are getting prepared for potential breaches in a way that is not only, as I said before, with the boosting of their policies, but using what is called the SIM software. So software that monitors network activity within the company and alerts the company when there are strange things happening. So essentially, this sort of software entails monitoring of employees' activity, and for that, there is a need of compliance measures. You cannot just go ahead and put in place this software and do nothing. So we have been working with these companies in helping with the compliance measures, and you can imagine, primarily, if you start monitoring the individual, you have to inform them that this is happening. There is a new sort of monitoring, which type of data, how is it used, what is the process. Very often this monitoring is one of those that requires DPIA, so these need to be put in place. It requires a legitimate interest assessment. Sometimes this is based on legitimate interest. Nobody's asked whether their data is going to be monitored, and we know that in the employment sector, consent is not good. So essentially, we have been helping put companies to put in place this software. Very often, this software is also accompanied by software that identify phishing attacks, not only network activity inside, but that coming from outside. Sometimes the phishing of employees to phishing attacks is monitored, and there might be even label of how each individual is doing, not to punish the individual, but maybe to then do targeting training for those employees who are not capable of identifying phishing attacks. So this is another thing, a lot of training of employees to for phishing mainly, and how to properly use the devices. So nets would be the sort of actions that have been done to cope with the myriad of new data processing that, and for that I put together apps that gather data, again, company based, then temperature taking, where have you been. Now we will see, I suppose we start with the vaccination. So facing with all of those, what we have been doing is a lot, again, data minimization. So always checking, can this be done with fewer data? Then notices, a lot of notices. We have done also a lot of care with data processor agreements. So for the COVID apps, for temperature, very often you use a third-party provider. So where is this third-party provider? You need the proper Article 28 clauses to make sure that they are very often processors, to make sure that they stay in the compound or confines of what they are supposed to do. And if they are outside the EU, then you need the proper standard contractual clauses with the Schrems additional clauses and additional technical measure that might be needed. So all of that has been done, and there is a lot of work towards making sure that the providers are doing what they are supposed to do, working for the company and no more. So this is a sort of maybe this is a sort of basic reflection of summary of the type of work done to cope with these additional security threats. I was wondering, when I was redoing this presentation, I was thinking, so if I had to summarize in like 5 or 6 bullet points, what would you say, Rosa? How could this compliance work be summarized? And I was thinking that, I mean, for sure, not as a compliance, but as a fact, I think that we have seen more collection, more monitoring. In terms of compliance, I would say that there has been many more notices, many more data privacy impact assessments, a lot of getting ready for data breaches with policies and learning, and quite a few more data breaches. Sort of these, in my view, sort of summarizes the year 2020. The sort of compliance work that a lawyer like me have done, and I would imagine that for many others is the same, and for the people working in the company. In this work, all these documents and guidelines that Peter has alluded to, that the EDP board has produced, all of that has been tremendously helpful, because as to guide companies, these are the sort of document that we are using on our daily basis. So I think with that, I finish my intervention. So, and happy to hear the co-panelists and to take questions at the end, if there are any.
Thank you very much, Rosa. It was really enlightening to hear about the perspective from the private sector and how business and organization, what they had to do in order to react and respond to this new normal. It is true and has also been acknowledged by several cybersecurity stakeholders, at least in the European ecosystem, that new threat vectors or attack vectors resurfaced or remerged due to this swift change from having to work from home, study from home. And also the aspect of new processing operations that emerged very quickly is also something that had also to be addressed by data controllers and processors. You mentioned about the COVID tracing apps, and with this I would like to pass the floor to Cédric to tell us how was 2020 for him and his experience with regards to the French app and the technologies that were used. Cédric, the floor is yours.
Yes, thank you. Thank you for the invitation in this very interesting panel. Previously, already a lot of things have been said about contact tracing application that have been mentioned by my co-panelists. So we got this pandemic, and to fight pandemics, healthcare authority often rely on contact tracing. So what is contact tracing? It's people who are going to interview people who have been infected to try to get all the people that may have been infected also. So it's based on interview, and people are collecting personal data, the personal data of the contact of an infected person. The thing that with COVID-19 pandemic was, can technology provide a solution to improve contact tracing? And that's the general idea of contact tracing application, is to try to use smartphone and Bluetooth technology to improve contact tracing, to try to contain the virus. So this is the philosophy and the idea behind contact tracing application. There are many lessons interesting that we have learned from designing such an application. The first one that is really super important is that in Europe, people have tried to design contact tracing applications that are privacy friendly by design. And it's really something really important that a lot of researchers in Europe and every country in Europe has tried to design a contact tracing application that is privacy friendly. Privacy was really the main focus of all those applications. And I would say that even sometimes privacy was has eclipsed the real finality of the application. Okay, because really this was the main concern. So this is really something very positive, is that in my opinion, for the first time, a technology has been designed with privacy as one of the main goal. The second lesson I can say that we have learned in the design of such an application is that code is law. So this is the title of a famous paper from Lessig back 10 years ago. It means that we have not done what we want when we have designed contact tracing application, because Bluetooth API are controlled by Apple and Google. They are controlled by companies, not by states. And this is really a big problem, because it creates a lot of design constraints that make extremely difficult for a designer to do what they really want to do. And this is really difficult. And in the end, everybody knows that Apple and Google, they have even created an API and provided this API to countries who want to design their own application. But there is a part of the technology that which is not under our control. And it's not under the control of any authority except Apple and Google. So it's something really difficult when you want to design such a contact tracing application. The question was, okay, how much information can you transfer using Bluetooth? Because the idea of those contact tracing application is to broadcast over Bluetooth signals some identifier pseudonym that are stored on other phone, and you are going also, your application is going to collect those identifier to create contact list and then share it more or less with healthcare authority. And it was really, really challenging to create a protocol in which we can only send a very small pseudonym, because it creates constraint for security, for confidentiality, integrity, to ensure that we are able to really preserve the privacy of the user of such application. So this was really, really challenging. So we had really to be smart to create those pseudonyms, and it was really, really challenging to do that. It was more challenging to notify user and to define what was learned by the healthcare authority, or because not everybody was agreeing on what need to be shared and how to minimize the data share with the healthcare authority, which leads sometimes to really heated discussion between scientists and states. It is really, so this is, I will say, another lesson learned from the design of such application. When you mix science and politics, it's complicated, and it's difficult because it creates pressure for scientists and for application designers. So this is really another lesson that we have learned, is that it's difficult to work under such a pressure. And I will say the final lesson is that in the end, so a lot of new protocols have been designed in the US, in Italy, in France with Desiree, in which we have improved how pseudonyms are generated, how they are created, which create really new opportunity to think what is pseudonymization and how it is achieved and done to protect personal data. And so this is really something extremely promising, because the technology has really been boosted by the effort of really plenty of researchers who have really focused on pseudonymization and how it is done, which really promise a lot of interesting advance, like thinking about collaborative pseudonymization as a service, which can really boost how the data are protected, and in the end, how personal data are handled by private companies. So, so this is, I think, the main lesson that we have learned in the design of contact tracing application. I will be very happy to answer all your questions later. Thank you.
Thank you very much, Cédric. It was also really enlightening to hear from a completely different of this last year, more specifically the very heavily debated point on content tracing apps, how it was perceived by somebody who worked in this area. I found it really interesting, but also very true, even from the outside, to hear that the mix of science and politics gets things complicated. And before I pass the floor to Fabian to tell us also his perspective from a more, let's say, again, hands-on from the medical side, but again with a focus on technology. It's really optimistic I felt really optimistic to hear your comment that technology has really boosted specific aspects of techniques such as pseudonymization. Fabian, the floor is yours.
Introduction also from my side. As Prokopios already mentioned, I will be giving more of a, let's say, field report in establishing biomedical research projects during the pandemic. The title of this panel is closely related to data protection, the new normal. So first of all, I would like to say that, of course, in medical research, protecting data is not a new normal, but we have been doing this for a long time with quite a lot of efforts. And but of course, with this pandemic that hit all of us, we are sort of in a different situation at the moment. So, let's see, I'm trying to change to the next slide. Perfect. So. Of course, also, in particular during a pandemic, medical research is very important. There are quite a lot of important questions that need to be answered. For example, of course, questions around the early detection and infection of COVID or diagnosis of COVID-19, the huge topic of drug and vaccine development. But of course, we also wanted to treatment monitoring and disease surveillance, and in order to sort of consider the fact that medicine is becoming increasingly more personalized, and also for the SARS-CoV pathogen, SARS-CoV-2 pathogen, we need to share data across institutions. Ideally, we would also need to create large research projects that share and data across, of course, the different countries within the European Union. And as I mentioned before, implementing data protection mechanisms into such research projects is not new, but we're doing this for quite some time already. But within a pandemic, the situation is different in the regard that we need a rapid response to what is happening. And there are challenges associated with establishing such research projects, and at the same time, protecting data according to laws and regulations, in that policies and interpretations are quite heterogeneous from my view, and there's a gap between what is described in laws, but also in guidelines, and what is actually technically feasible, leading to legal uncertainties, and in particular leading to the need to invest quite a lot of time and efforts into really setting up research projects, considering these requirements. And I found it very interesting what Peter Kraus said, that there is a lack of awareness also regarding, for example, general terms such as what is actually personal data, what's the difference between pseudonymized data or anonymized data. And I can just second this. There's definitely a lack of awareness around these terms. But I would also argue that this also has to do with the fact that there is a lack of standards, there's a lack of consistent interpretations, and a lack of adequate guidelines. Because even for me as a data protection, I would say, experts working in particular on the technical side for several years, I also often really have difficulties in interpreting the terms that are, for example, mentioned in according regulations. And just to give you sort of a very quick example of this, the question of anonymity and personal data and identifiability, just one example from the GDPR, in this case, where it's stated that the principles of data protection should only apply to information that is concerns an identified or identifiable natural person. So it's really this question, does the GDPR even apply to a certain processing that we are doing? And the sort of description here is really open to interpretation. Try to switch to the next slide. So first of all, while I'm waiting for the next slide, there's really question what actually is identifiability from a technical perspective. This is definitely not something that is binary. It has to do with how do you say? So it's basically a spectrum of identifiability. There are also many different ways in which certain types of information or derived information can or could potentially be associated with individuals. Then, as recital 26 says, that when we reason about identifiability, we should take into considerations means that are reasonably likely, and there are many questions, of course, around what is reasonably likely. Are there any thresholds for this, or should we take an absolute or relative position on anonymity or identifiability? And then it is further stated that you should take into account objective factors when you reason about likelihood. And of course, there's the question that comes up, what are such objective factors? There are a few examples, but there might be additional factors. How can we quantify and measure these factors? So a range of aspects that are open to interpretation, in my perspective, also in my practical experience, when dealing with very basic terms. And just to give you, and also what I wanted to highlight is that when you talk, my experience, when you talk to different people, so let's say different institutional data protection officers or different supervisory authorities or to different lawyers or different technicians, you typically get different answers to these questions. And of course, there are already quite a few guidelines and also some reports. This is with a focus on documents that also contain information on data anonymization in worldwide perspective. But middle, I've highlighted a few of the guidelines and reports from within the European Union. And if you take a look at these, what they actually say about identifiability and about data anonymization, there's also quite a lot of heterogeneity within the different reports, some taking an absolute position, some taking a relative position, for example, and recommending different ways of measuring the degree of identifiability as possible. So on my last slide, I would like to give 2 examples of projects that I was involved in, medical research projects that dealt with aspects of creating or are still dealing with aspects of creating larger data pools for studying SARS-CoV-2 and COVID-19. And the first example is a European registry, which has really been rapidly been established at the quite very beginning of the pandemic, based on the principle of anonymity of data. And I was involved in how this was constructed, and it really took tremendous efforts and extensive time and extensive documentation and studying of various guidelines that are already mentioned to come up with a concept which allowed us to realize this. I would like to highlight the opinion on anonymization methods by the Article 29 Data Protection Working Party that many of you might be aware of, as my experience, one of the documents with more concrete guidance, but still open to quite a lot of interpretation. And another project where, as opposed to establishing a new registry or data collection, the idea is of connecting all those different research cohorts that have been established across the European Union into sort of a common network, providing access to a large pool of health and biomedical research data for studying COVID-19 is going on. Basically, I can just say that from within this project, there are significant efforts that are required to even obtain an overview of how data protection has been implemented into these various types of cohorts, because there are quite a lot of differences also on a country level. Again, referring to what Peter Kraus said, there's definitely a lack of awareness. There are huge differences in interpretations, and it's already challenging to derive a common understanding of how data protection needs to be implemented when dealing with cross-border projects in particular. And maybe as my last words, this applies to many aspects of data protection. I mentioned anonymization and identifiability as an example, because this is an area where I have worked in a lot. But also if we think about data protection impact assessments, how do they need to be structured? When is it actually necessary to perform them? What is the degree of detail in which research projects and processes, the data, the systems within them or used by the projects need to be studied and described within such assessments? And how can we implement data protection and information security by design into such projects? So these are all really complex topics, and I really think that we do need more standards. We need more consistent interpretations and also more operational guidance. So looking forward to the discussion. Thank you very much for your attention.
Thank you very much, Fabian. It was really interesting to also see the research perspective and more practical from the medical point of view. I would like now to open the floor from questions, to take questions from the audience. But until currently I do not see any question. So in the meantime, I would like to you emphasized or you closed your intervention by mentioning that we need more guidance. You even brought up guidance from the Working Party 29 that I believe it's more than 5 years old, acknowledging the fact that currently, or due to the pandemic, all this circle from performing research on a specific topic or area until we reach policy initiative has had to be dramatically shortened without taking any shortcuts with regards to data protection and privacy. I would like to ask, first of all, Peter, as being a representative of the regulators, of the body of the regulators, to what direction he thinks the guidelines should come in the near future, specifically in the case of handling, processing personal data in the context of COVID or relevant application, in the terms of, let's say, a more legal interpretation, a little bit more practical on concepts by providing additional use cases, so setting up the ground like the EDPB did with the recent opinion on the by design feeling, without preempting, of course, what the EDPB will actually do at the end.
Thank you, Prokopios. So I think the most recent example is probably what you had in mind. We just recently published a document on examples of data breaches, and that included some sort of risk assessment of examples. So this is also tying in with what Rosa mentioned earlier, that this is an issue that we have observed. And well, as generally we have our plan, and also the topic of anonymization is something that we're aware of, that there is the need for further clarification. So I have to be honest that even the Working Party 29 document that is around was already addressing technologies that are still relevant, like synthetic data, etc. So we are looking also at the previous documents and seeing which ones we should reevaluate and update or provide a new version. And this could be one where this is definitely helpful for everybody. I just wanted to react as well to our colleague from Germany that just mentioned the recital about anonymous data. And I think one of the important parts that was unfortunately not in the quote of the recital is that the recital is it's very how do you say, it doesn't leave a lot of wiggle room for what is anonymous data, because the part that was missing in there, that it talks about reasonable means not only by the controller but by any person, and that makes it even more difficult for data to become anonymous data. I hope that somewhat answers your question.
Thank you very much, Peter. We have two questions. One is addressed specifically to Cédric. He seems to have an audience. And I believe also the second one fits to what Cédric mentioned about the privacy-enhancing technology. However, any one of the panelists is more than welcome to react after Cédric. So the first question, Cédric, is what you think about the possibility to see blockchain as a privacy-enhancing technology. And is Bluetooth absolutely essential to the data privacy applications, or there are other ways of implementing the same functionalities without using Bluetooth so as to escape the private companies like Google and Apple?
Yes, so about the blockchain, this is definitively a great idea. And it was one research team in Italy has designed a protocol that use a blockchain instead of providing data to an healthcare authority. And this is really something very promising and interesting solution. So yes, definitively. I was, to be honest, for a lot of time skeptical about the opportunity to use blockchain to enhance privacy or as a privacy enhancing technologies. But for contact tracing, definitively, this is something extremely interesting and promising. So this will be my first answer, because it minimizes potentially any risk of manipulation by an authority. So this has to be taken into account. For the second question about Bluetooth, so Bluetooth was chosen because it's a technology available on every smartphone, and it's used to determine if there is a contact or not between several people. The question is, what is the best technology? So there have been a lot of work on that. It's possible to use also QR code to add something more reliable. There are other technologies for sure. Some are more or less intrusive, because if you collect the GPS data, you can be very precise to determine if two people has been in contact, but it's extremely intrusive because you got really a lot of information. It's a bit difficult to know which technology is the best and is the most privacy friendly. For sure, Bluetooth has some issue, but this was the choice for contact tracing application because it was available on every phone. I said that it has boosted the design of contact tracing application has boosted research on pseudonymization. It has also boosted research on Bluetooth and what can be done with Bluetooth, because for the first time, it was done at least in France, but I think it's many other countries. Really large-scale studies of what can be done with Bluetooth to detect contact between people, and so for that respect, we have learned also a lot about Bluetooth during the design of contact tracing application.
Thank you very much, Cédric. There is another question with regards to the previous, with regards to the first one. It mentions, doesn't blockchain collide with principles like data minimization, the right to be forgotten, etc.? I can only assume that your initial response was not directly linked to the context of the pandemic or a contact tracing app, but if it was, it also included implied the addition of additional privacy enhancing technologies in order to address this.
Yes, for me, blockchain is an alternative to provide data to an authority, and there is a question of trust. And with a blockchain, as everything is visible, you don't put your data in the hand of an authority, and you know it's related to the culture and to the notion of privacy, and it's different from the country. And in some countries it is like in France, it is acceptable to provide data to a healthcare authority, and you can provide quite a lot of data, and people agree with that. But in other countries, it's not unacceptable. And with a blockchain, you provide an alternative where you are going to provide data to something else than an authority that everybody can look at and trust. Of course, the right to be forgotten can be an issue, and you need to be really careful with the design and the use of the blockchain, but it really provides an alternative. And nobody has really thought about it at the design of contact tracing application, and it appears only later. And this is really a super idea to try to use blockchain.
Thank you very much, Cédric. Another question relates to the immunity passports. I guess we can first address the vaccination passport, because perhaps immunity is something that we wish with regards to COVID after taking the vaccine. So if the participant will allow me to rephrase it to vaccination password, I will not go directly to Peter, but I would like to hear what Rosa thinks with regards to this, if there are any by the introduction of vaccination passwords. And then perhaps to Fabian, what this could be from a research perspective, what such a passport could contribute, or what would be the added value apart from being able to display it, if there is any. Rosa, what are your thoughts? I know it's a very tricky subject, so at this moment it's just your thoughts. I think you're muted. No, okay, you're fine. No, we don't hear you, Rosa. Yeah, Fabian, until we sort out the problem with Rosa's microphone, perhaps you can tell us if this vaccination passport could mean something additional to researchers, or apart from being able to display it and be able to board a train or a plane. What are your thoughts, at least?
Yeah, I mean, it's a topic that I have not thought about, as I said, a lot from the medical research perspective. I mean, in general, I can say that having an electronic representation of at least of vaccination information is of course also quite important in medical research, and it's also a challenge because in many countries there's sort of quite a diversity in how the healthcare sectors are constructed, and there are not necessarily solutions available that can help to sort of make this data available also for research on a larger scale, right? So so at least like this is not a data, would be an important type of information also from the medical research perspective when it comes to vaccination, not necessarily so much when it comes to immunity. And thinking about this from a privacy perspective, maybe this could be a question that's also going a bit in the direction of Cédric, whether there might be privacy preserving protocols or approaches for managing this information in a way that still remains useful. But as I said, this is not something that I have thought about.
Yeah. Thank you very much for this reflection. Rosa, I'm afraid we... okay, so we're still working on the problem. So until Rosa, until we manage to hear also Rosa's point of view, I would like to just reflect on the fact that the data protection implications have to be discussed based on the processing operation that which such information and the password itself could be used. So this would be my personal point of view. And I would also like to get Peter's point of view with regards to, even if this is just a policy initiative, what could the possible contribution of the national and the ATP be towards this direction? Again, as a personal reflection, of course.
Yes, thank you. Yeah, so in my opinion, the very first thing to consider is that we already have vaccination passports for other purposes. If anybody ever traveled to South America, for instance, there are countries that require you to have a certain vaccination to enter. So as such, it's not a new concept, in my opinion. To my knowledge, we are not required to do it anywhere within Europe, and that's the new discussion that we will have, or that we will need to have. From the perspective of the regulators, I think for us it's important that we are consulted early so that we can look at what is the concrete implementation, because in the end it will always depend on the concrete implementation, and so that we can contribute and highlight where there could be potential problems.
Thank you very much, Peter. Let's try one more time with Rosa.
I think now it should work.
Oh, great, yes, it works.
So when I think about that, I always think as a lawyer, and so the first thing that you think is, what is the legal basis? So so in order to put forward this passport vaccination, the countries will probably have to put them forward, and you will need a legislation. So what will this legislation will have to have the checks and balances, what it will look like, and going back to Peter, then which information would it have? So this will be my first thing that you need to sort out, the legal basis. And then I think there is a subsequent question that is very interesting. To what extent companies that offer services, and by services meaning an airline, a restaurant, can they allow or deny access to their services to those who do not present the proper vaccination certificate or whatever we call it? So is this lawful? Is it not lawful? I think this is a can of worms, and is one of the questions that probably will have to be answered, whether it is lawful to do so.
Yeah. So I completely agree with the second part, because the first part, I believe, of course, there is room to explore and discuss the but I think it should not result in what we have been discussing all this time about the privacy with regards to the cookie wall. So we should not end up with a passport or a certificate, vaccination certificate wall. As we only have 2 times until we have to conclude this discussion, I would like to get one very quick final thought from each one of you. Thanking you for your participation, your very insightful comments and thoughts. And let's start with Rosa.
Final thought. So my final thought is that I hope that as we are moving forward, this enhanced security preparation and putting in place compliance measure that we have seen continues and does not become like an ad hoc thing that of 2020, but it continues throughout time.
Thank you very much. Fabian?
Yeah, I'm really hoping that those guidelines, for example, that I mentioned, will be created, and I would like to highlight that this is something that is important not only in the context of this or future pandemics, but for medical research and probably other application fields as well in general. Thanks.
Thank you very much, Fabian. Cédric? We cannot hear you.
Sorry. So I will say that privacy is not a lost cause. It's gaining ground, and technologies are going to improve and to be more and more privacy friendly.
Thank you very much. And last but not least, Peter?
Thank you. I think what it has shown us in the last year is that how important data protection is as a fundamental right. And it has also shown how much more people are getting to exercise their rights and becoming aware of what it means to them in the current context. So I hope this continues so people appreciate the protection that is offered to them.
Indeed. Thank you very much, Peter. And all 4 of you have mentioned the need or the request for awareness throughout this new normal. So it's something that we'll definitely need to look into, each one of us, from our own perspective. I would like to thank you again for accepting and participating in this discussion, and wish to all the participants an enjoyable rest of the conference. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.